आज की इस वीडियो में हम मध्य प्रदेश जुडिशियल सर्विस एग्ज़ाम ऑफ सिविल जज जूनियर डिवीजन एंट्री लेवल का पेपर है वो डिस्कस करेंगे। तो क्वेश्चन नंबर फर्स्ट देखते हैं। इसमें फर्स्ट नंबर क्वेश्चन जो है वो दे रखा है, कॉन्स्टिट्यूशन ऑफ इंडिया केस रिलेटेड टू प्रोटेक्शन अगेंस्ट हैंडकफिंग। प्रोटेक्शन अगेंस्ट हैंडकफिंग का केस जो है वो है प्रेम शंकर वर्सेस दिल्ली एडमिनिस्ट्रेशन। According to which article of Constitution of India the state shall endeavour to protect and improve the environment and to safeguard the forest and wildlife of the country. Important article है 48A. Article 48A of Constitution of India. The state shall endeavour to protect and improve the environment and to safeguard the forest and the wildlife of the country. The word socialist and secular इनको कब इंसर्ट किया गया था कॉन्स्टिट्यूशन में? तो ये किया गया था 42nd अमेंडमेंट ऑफ द कॉन्स्टिट्यूशन इन 1976। अगला क्वेश्चन है कि बाय विच अमेंडमेंट इन कॉन्स्टिट्यूशन ऑफ इंडिया आर्टिकल 21A दैट द स्टेट शैल प्रोवाइड फ्री एंड कंपल्सरी एजुकेशन टू ऑल चिल्ड्रन ऑफ द एज ऑफ 6 to 14 years in such manner as the state may by law determine was inserted। तो 21A को कब इंसर्ट किया गया था ये पूछा गया है। तो 86th अमेंडमेंट एक्ट जो था 2002 का, उसमें इसको इंसर्ट किया गया था। इम्पोर्टेंट है, सारे क्वेश्चन काफ़ी इम्पोर्टेंट है। कॉन्स्टिट्यूशन ऑफ इंडिया द नंबर ऑफ कैटेगरी ऑफ फ्रीडम गारंटेड बाय आर्टिकल 19 इज। तो कितने टाइप की फ्रीडम है वो आर्टिकल 19 में दी गई है। तो 6 टाइप की फ्रीडम जो है वो दी गई है। तो ये डिटेल से आप देख सकते हैं। इसमें जो एफ नंबर की थी उसको ओमिट कर दिया गया है, प्रॉपर्टी वाली। तो अब 6 हैं टोटल। अगला क्वेश्चन है क्वेश्चन नंबर 6। रिट अंडर आर्टिकल 32 ऑफ कॉन्स्टिट्यूशन ऑफ इंडिया इज नॉट सब्जेक्ट टू एनी ऑफ द एक्ट्स इन इंडिया। Article 32 of the Indian Constitution deal with the right to constitutional remedies or affirms the right to move the Supreme Court by appropriate proceeding for the enforcement of the fundamental rights. Article 32 is not subject to any of the acts in India. Constitution of India Hicklin test under Article 19(2) is related with. This is related with decency and morality. Next, a Constitution of India. Which one of the following pair is correctly matched? रिट ऑफ मैंडेमस करेक्टली मैच्ड पूछा है यहाँ पे। रिट ऑफ मैंडेमस इशूड टू द पब्लिक सर्वेंट, तो सही बात है, पहला ही सही हो गया इसमें। इशूड टू पब्लिक सर्वेंट नॉट टू प्राइवेट पर्सन्स। इट इज़ यूज्ड फॉर इन्फोर्समेंट ऑफ वेरियस राइट ऑफ द पब्लिक और टू कंपेल द पब्लिक स्टैट्यूटरी अथॉरिटीज टू डिस्चार्ज देयर ड्यूटीज एंड टू एक्ट विद इन द बाउंड्स। एंड इसके अलावा बाकी जो है उनको भी एक बार आप देख लेना। Constitution of India, the subject of preventive detention mentioned in which list? In the concurrent list. Entry 3 of Constitution of India. Constitution of India, the dissenting judgment in the case pertaining to the scope of application of the Aadhaar Bill was given by Justice D.Y. Chandrachud. Next है CPC. Which of the following order of CPC is related to written statement, set off and counter claims? तो ये वाला क्वेश्चन है, ये लास्ट पेपर में भी था, तो आएगा 8। Order 8 of Civil Procedure Code provides written statement, set off and counter claim. अगला है CPC गार्जियन एंड लिटेम यूज्ड अंडर CPC कोड 1908। इसका क्या मीनिंग है? इसका मीनिंग है ए पर्सन अपॉइंटेड बाय द कोर्ट टू डिफेंड ए सूट ऑन बिहाफ ऑफ ए माइनर। अगला क्वेश्चन है काफ़ी इजी क्वेश्चन, डिक्री का क्वेश्चन पूछा है कि डिक्री कहाँ पे डिफाइन है CPC में, तो 2.2 में डिफाइन है। डायरेक्शन ऑफ द कोर्ट टू ऑप्ट फॉर एनी वन मोड ऑफ अल्टरनेटिव डिस्प्यूट रिजोल्यूशन इज प्रोवाइडेड इन। दिस इज प्रोवाइडेड इन ऑर्डर 10 रूल 1A CPC। Under which section of CPC clerical or arithmetical mistake in judgment, decrees or order or error arising therein from any accidental slip or omission may at any time be corrected by the court either of its own motion or on the application of any of the parties in section 152. Civil Procedure Code, in which one of the following cases it is held that inherent power has not been conferred on a court, it is a power inherent in a court. Manohar Lal Chopra versus Rai Bahadur Raja Seth Hiralal. Civil Procedure Code, the doctrine of res judicata as contained in section 11 is based on which maxim? Based on the maxim interest republicae ut sit finis litem, which means that it is in the interest of the state that there should be an end to litigation. Civil Procedure Code, where any party dies after conclusion of the hearing and before pronouncing judgment, then what will happen? The suit shall not abate. रूल 6 ऑफ ऑर्डर यहाँ पे 22 ऑफ सिविल प्रोसीजर कोड में ये दिया गया है. CPC, the judgment debtor in execution proceeding raised objection that the trial court had no jurisdiction over the subject matter. He cannot raise such objection unless he raised the same objection before the trial court. ये गिवन है सबसेक्शन 5 ऑफ सेक्शन 21 में. ए नेक्स्ट फ्रेंड और गार्जियन ऑन बिहाफ ऑफ माइनर अंडर ऑर्डर यहाँ पे दिया गया है 32 रूल 7 ऑफ CPC can neither enter into an agreement nor compromise the suit without leave of the court. In which of the following section of CPC the arrest or detention for money is prohibited? वुमेन्स के लिए ये प्रोहिबिटेड है. अगला है सिविल प्रोसीजर कोड, इन विच केस सुप्रीम कोर्ट हेल्ड दैट पोजेशन फॉलोज टाइटल. Nazir Mohammed versus J. Kamla and others. Civil Procedure Code A, B, C, D, and E are jointly and severally liable for rupee 1000 under a decree obtained by F. A obtain a decree for rupee 1000 against F singly and applies for execution to the court in which the joint decree is being executed, which is true under order 21 rule 18. F may treat his joint decree as a cross decree. CPC, which of the following order is not appealable? Commissions to make local investigation is not appealable. ऑर्डर यहाँ पे 26 रूल 9. Under section 37 of CPC 1908 in relation to the execution of decrees, the expression court which passed a decree has deemed to include the court which passed a decree, the court of first instance where decree has been passed in the exercise of appellate jurisdiction, appellate court where decree has been passed in the exercise of appellate jurisdiction. तो 25 के में क्या आएगा? फर्स्ट एंड सेकंड दोनों ही आएंगे 25 के में. इसके लिए 37 ऑफ CPC देख सकते हैं. नेक्स्ट है अंडर सेक्शन 19 ऑफ द ट्रांसफर ऑफ प्रॉपर्टी एक्ट वेस्टेड इंटरेस्ट इज not defeated by the death of the transferee before he obtains possession. अगला क्वेश्चन है Transfer of Property Act A transfer रुपए 500 to B on condition that he shall execute a certain lease within 3 months after A's death, and if he should neglect to do so, C B dies in A's lifetime. The disposition in favor of C takes effect. The foundation of doctrine of election under the Transfer of Property Act 1882 is that the person taking the benefit of any instrument must bear the burden. Transfer of Property Act, the mortgager's right to redeem the mortgage property accrues at any time after the mortgage money has become due. सेक्शन 60 देख सकते हैं इसके लिए. ट्रांसफर ऑफ प्रॉपर्टी एक्ट ए ट्रांसफर प्रॉपर्टी ऑफ विच ही इज द ओनर to be in trust for A and his intended wife successfully for their lives, and after the death of the survivor for the eldest son of the intended marriage for life, and after his death for A's second son, the interest so created for the benefit of the eldest son does not take effect. इसके लिए देखना पड़ेगा सेक्शन 13 ऑफ टीपीए. Transfer of Property Act. The case of Jayadayal Podhar versus Bibi Hajra is related to ostensible owner. It is well settled that the burden of proving that a particular sale is benami and the apparent purchaser is not the real owner always rests on the person asserting it to be so. Transfer of Property Act, where the mortgagor ostensible sells the mortgage property on condition that on default of payment of the mortgage money on a certain date the sale shall become absolute, is called mortgage mortgage by conditional sale. इसके लिए देखेंगे 58 section of TPA. Indian Contract Act. The contract of life insurance is contract of indemnity, contract of guarantee, contract of agency. ए होगा इसका आंसर. Indian Contract Act. Every agreement to restrain marriage of any person other than minor is void. Section 26 of Indian Contract Act. Every agreement in restraint of the marriage of any person other than a minor is void. Indian Contract Act. Where no application is made and no time is specified for performance of promise, then the agreement be performed within reasonable time. Section 46 of Indian Contract Act says that whereby the contract a promisor is to perform his promise without application by the promise and no time for performance is specified, the engagement must be performed within a reasonable time. Next है Indian Contract Act. A contract by which one party is promised to save the other from loss caused to him by the conduct of the promisor himself or by the conduct of any other person has been defined in Section 124 of the Indian Contract Act. Indian Contract Act. An agency is terminated by the agent renouncing the business of the agency by the principal being adjudicated and insolvent by revoking of authority by principal. तीनों ही सही है. इसके लिए 201 ऑफ इंडियन कॉन्ट्रैक्ट एक्ट देख सकते हैं. आई सी है. नेक्स्ट है इंडियन कॉन्ट्रैक्ट एक्ट. इन द केस ऑफ जनरल ऑफिस देयर इज नो नीड टू कम्युनिकेट द एक्सेप्टेंस इफ नॉट रिक्वायर्ड बाय द प्रपोजर. दिस हैज़ बीन डिसाइडेड इन विच वन ऑफ द फॉलोइंग केस. आंसर इज डी. Carlyle versus Carbolic Smoke Ball Company, 1892. It is an English contract law. It was held that an advertisement containing certain terms to get a reward constituted a binding unilateral offer that could be accepted by anyone who performed its terms. Next is Indian Contract Act. In case of acceptance by post, at what points the acceptance is complete as against the proposer. Section 4 of Indian Contract Act. The communication of an acceptance is complete as against the proposer when it is put in a course of transmission to him so as to be out of the power of the acceptor, as against the acceptor when it comes to the knowledge of the proposer. Indian Contract Act. Mark the correct answer in respect of contract of guarantee. It may either oral or written. 126 देखना पड़ेगा इसके लिए ICA का. अगला है specific relief act. No substituted performance of contract under subsection of section 20 shall be undertaken unless the party who suffers such breach has given a notice in writing or not less than days to the party in breach calling upon him to perform the contract within such time as specified in the notice. 30 days. Section 8 of Specific Relief Act can be invoked when the thing claimed is held by the defendant as the agent or trustee of the plaintiff, when compensation in money would not afford the plaintiff adequate relief for the loss of the thing claimed, and when the possession of the things claimed has been wrongfully transferred from the plaintiff. Following is not the essential condition for applicability of Section 8 of the SRA. दिया गया है यहाँ पे कौन सी कंडीशन नहीं है. द डिफेंडेंट मस्ट बी ओनर ऑफ द प्रॉपर्टी, द आर्टिकल मस्ट बी मूवेबल प्रॉपर्टी, द प्लेंटिफ मस्ट बी entitled to immediate possession of the article must be possession of control of the defendant. ए आएगा आंसर इसका. अंडर section 37 of SRA, a temporary injunction can be granted at any stage of the suit. ये क्वेश्चन भी रिपीट हुआ है. Specific Relief Act. According to the Section 20C, notwithstanding anything contained in the Code of Civil Procedure, a suit filed under the provision of this Act shall be disposed by the court within period of from the date of service of summons to the defendant. Twelve months. Section 20C देख सकते हैं इसके लिए SRA का. Which new remedy inserted by SRA 2018? Substituted performance. Which section of the Limitation Act 1963 is based on the principle of lex non cognitat impossibilia? 47 के में आंसर होगा सेक्शन 4. Section 4 of Limitation Act provides for the expiry of prescribed period when court is closed. Under Section 21 of Limitation Act, when the suit shall be deemed to have been instituted as against the newly impleaded defendant, the date on which he was impleaded. Limitation Act, in which case Supreme Court has held that where a plaintiff serves notice under Section 80 CPC on the defendant on the last day of limitation and file suits before the expiry of 2 months, which is entertained by the court in view of the provisions of Section 82 CPC, the plaintiff would be entitled to get the period excluded under this section. Union of India versus West Coast Paper Mills Limited, as per the bare provision of Section 4 of Limitation Act 1963, shall be deemed to be closed on a day within the meaning of this section if during any part of its normal working hour it remained closed on that day. 51 का आंसर है सी। ये स्टेट स्पेसिफिक है इसलिए नहीं करेंगे। The principle of Section 44 of the Indian Evidence Act 1872 cannot be extended to which of the following? मिसरिप्रेजेंटेशन और अनड्यू इन्फ्लुएंस। तो इसके लिए 44 हम देखेंगे। इंडियन एविडेंस एक्ट 1872, द केस ऑफ सवाई दास वर्सेस स्टेट ऑफ बिहार 1974 इज रिलेटेड टू रेस गेस्टे। इंडियन एविडेंस एक्ट 1872 एन एक्यूज चार्ज अंडर सेक्शन 302 304 बी ऑफ penal कोड इज एक्वायर्ड ऑफ द ऑफेंस अंडर सेक्शन 302 ऑफ penal कोड। द प्रिजम्पशन अंडर सेक्शन 113 ऑफ द एविडेंस एक्ट इज not refuted. Indian Evidence Act 1872, which of the following section of the Indian Evidence Act does not relate with the criminal matters? Section 23 of Indian Evidence Act deals with admissions in civil cases when relevant. Under Section 45 of the Indian Evidence Act, the opinion of experts are relevant fact as to identify the handwriting and identify the finger impression both. Indian Evidence Act 1872, which of the following statement is not correct in relation to words and expression used in Section 3 of the Indian Evidence Act? बी गलत होगा क्योंकि कोर्ट इंक्लूड ऑल जज एंड मजिस्ट्रेट एंड ऑल पर्सन एक्सेप्ट आर्बिट्रेटर लीगली ऑथराइज्ड टू टेक एविडेंस. The court doesn't include arbitrator. In which of the following case the evidence given by the witness will not be relevant under Section 33 of the Indian Evidence Act 1872? When the witness is staying abroad. इसके लिए देखेंगे सेक्शन नंबर 33 इंडियन एविडेंस एक्ट 1872. अंडर सेक्शन 90 ऑफ इंडियन एविडेंस एक्ट 1872, प्रिजम्पशन एज टू इलेक्ट्रॉनिक रिकॉर्ड्स 5 years old is provided. Indian Evidence Act 1872, which kind of jurisdiction is not mentioned under Section 41 of the Indian Evidence Act 1872? Revenue. Indian Evidence Act 1872, the document means a map, an inscription, a caricature, lithographed and photographed, all of these. Public document under Indian Evidence Act can be proved by certified copy. इसके लिए देखेंगे 77 नंबर इंडियन एविडेंस एक्ट का सेक्शन. Such certified copies may be produced in proof of the content of the public document of parts of the public document of which they purport to be copies. Indian Evidence Act 1872, a witness who is unable to speak give his evidence by written in open court. Evidence so given shall be deemed to be ओरल एविडेंस. ये हमने लास्ट भी देखा था, लास्ट पेपर में भी पूछा गया था. 119 का सेक्शन है. इंडियन एविडेंस एक्ट 1872, ए डाइंग डिक्लेरेशन रिकॉर्डेड बाय द पुलिस ऑफिसर इन द फॉर्म ऑफ FIR बिफोर द डेथ ऑफ द ऑथर विदाउट obtaining certificate as to his mental fitness can be treated as dying declaration. Indian Evidence Act 1872, which section of the Indian Evidence Act 1872 is founded upon the doctrine laid down in Picard versus Sears. Section 115. The principle of estoppel was established in the case of Picard versus Sears, where a person by his words or conducts induced to another person to believe a fact and subsequently acts according to that belief or to alter his previous position. The accused is barred from later changing his position. Indian Evidence Act 1872 under subsection of Section 65 B of Indian Evidence Act, a computer output shall be taken to have been produced by a computer in this statement which one is complete, whether it was produced by it directly or by means of any appropriate equipment. Indian Penal Code, when a woman was taking bath in her bathroom, X captures the image in his mobile. What offense has been committed by X? Voyeurism. Section 354 C of Indian Penal Code. Indian Penal Code, where an offence is punishable with imprisonment as well as fine, the term for which the code directs the offender to be imprisoned in default of payment of a fine shall not exceed one fourth of the term of imprisonment, which is the maximum fixed for the offence. According to the Indian Penal Code, A hits Judd 50 times with a stick. If the punishment for a strike is 1 year, then A will be punished with 50 years of imprisonment. When A is hitting Judd, Y intervenes and A deliberately kills Y as well. A is liable to one punishment for voluntarily causing hurt to Judd and another punishment for killing Y. तो ओनली टू, तो जो ज़्यादा रिग्रेस है वो मिलेगी, यहाँ पे 2 आएगा. Which one is not an exception of defamation under section 499 of IPC 1860? Malicious statement are not an exception defamation under section 499 of IPC. Indian Penal Code, the right of private defense of body does not extend to voluntary causing of death of the offender in which of the following offense? Causing miscarriage. सेक्शन 100 ऑफ इंडियन पिनल कोड देख सकते हैं इसके लिए. इंडियन पिनल कोड 1860 कॉमन इंटेंशन एंड सिमिलर इंटेंशन वाज डिस्टिंग्विश्ड इन विच केस? इन महबूब शाह वर्सेस एम्परर 1943. एक क्वेश्चन छूट गया यहाँ पे. इंडियन पिनल कोड 1860, द टाइम ऑफ सॉलिटरी confinement, a time not exceeding months of the term of imprisonment shall exceed 1 year. इसके लिए 73 ऑफ IPC देख सकते हैं. 3 months आएगा. How many kind of kidnapping are there in Indian Penal Code? 2 kinds of kidnapping. सेक्शन 59 है इसके लिए IPC का. किडनैपिंग इज ऑफ 2 kind, किडनैपिंग फ्रॉम इंडिया एंड किडनैपिंग फ्रॉम लॉफुल गार्जियनशिप. अंडर विच सेक्शन ऑफ द इंडियन पिनल कोड is the non-treatment of victim by public or private hospitals punishable? 166B. Consent given by a child below years of age is not deemed as consent under section 90 of Indian Penal Code 1860 unless the contrary appears from the context, if the consent is given by a person who is under 12 years of age. Indian Penal Code 1860, disclosure of the identity or name of the victim of rape is punishable under which of the following section of the Indian Penal Code in 1860? ये भी क्वेश्चन रिपीट हुआ है सेक्शन 228 से। इन विच सेक्शन ऑफ द इंडियन पिनल कोड कोर्ट ऑफ जस्टिस इज डिफाइंड। ये भी रिपीट हुआ है 20 सेक्शन 20। 88 इंडियन पिनल कोड द पनिशमेंट प्रोवाइडेड फॉर ऑफेंस ऑफ सेडिशन अंडर 124 ए ऑफ आईपीसी इज imprisonment for life, to which fine may be added, or with imprisonment which may extend to 3 years, to which fine may be added, or with fine. Indian Penal Code coin is defined in which section? 230. Indian Penal Code. A finds a watch on the floor of a state transport bus. While he was leaving it as a last passenger, he picked it up and put it in his pocket instead of returning it to the state transport authorities. Next day, he sold A is liable for criminal misappropriation. 403 देख सकते हैं इसके लिए आईपीसी का। प्रोसीडिंग अंडर सेक्शन 258 ऑफ कोड ऑफ क्रिमिनल प्रोसीजर कैन बी स्टॉप्ड in a summon case instituted otherwise than upon a complaint. A declaration of forfeiture under section 95 of the Code of Criminal Procedure can be set aside by High Court. Power conferred under section 311 of CRPC to summon material witnesses may be utilizing by court at which stage? Any time before pronouncement of judgment, during inquiry or trial. Under section 309 of the Code of Criminal Procedure 1973, magistrate can remand an accused to custody for maximum of 15 days a time. Under section 200 of the CRPC, the magistrate need not meet the complaint and the witness if the complaint is made in writing by a public servant in the discharge of his official duty, in which case the Supreme Court held that section 125 of CRPC applicable to all irrespective of their religion. Muhammad Ahmad Khan versus Sahbano Begum. It was held that a man with means, irrespective of his religion, must maintain his wife, children, and parents. Which section of CRPC provides that the public prosecutor in charge of a case may, with the consent of the court at any time before the judgment is pronounced, withdraw from the prosecution of any person in respect of any offense for which he is tried. Section 321 क्रिमिनल प्रोसीजर कोड फॉर ऑथराइजिंग सीआरपीसी का 321 देखना है इसके लिए। क्रिमिनल प्रोसीजर कोड फॉर ऑथराइजिंग डिटेंशन ऑफ अक्यूज्ड इन कस्टडी ऑफ द पुलिस, द अक्यूज्ड मस्ट बी प्रोड्यूस्ड बिफोर द मजिस्ट्रेट इन पर्सन। सेक्शन 56 देखना है इसके लिए सीआरपीसी का। अंडर सेक्शन 468 सीआरपीसी, द लिमिटेशन फॉर टेकिंग कॉग्निजेंस ऑफ एन ऑफेंस विच इज पनिशेबल विद इम्प्रिजनमेंट फॉर ए टर्म एक्सीडिंग 1 year बट नॉट एक्सीडिंग 3 years इज 3 years. Under section 357(2) of Criminal Procedure Code, which of the authorities authorized to decide quantum of compensation? State Legal Service Authority or District Legal Service Authority. Criminal Procedure Code. Evidence rendered in court is substantive evidence. It would be impermissible to convict the accused on the basis of the statement made under section 164 CRPC. It was held by the Supreme Court in the case Soma Sundaram Somo versus State, the Deputy Commissioner of Police. For the application of section 300 of the Code of Criminal Procedure 1973, which one of the following is incorrect? Incorrect statement है कि it is not necessary that the court who conduct the trial was competent or not to try the case. तो common sense हो जाएगा ये. Criminal Procedure Code, in which case the Supreme Court held that no second FIR can be of same incident. In such case, first FIR shall be treated Man FIR and other will be treated as statement under section 162 CRPC. Amish Devgan versus Union of India and others. Section 293 of CRPC does not apply to which government scientific expert? State examiner for the questioned documents. Criminal Procedure Code 1973, to whom the court may appoint as administrator for management of properties seized or forfeited under Chapter 7A of the Criminal Procedure Code 1973. District Magistrate or officer nominated by District Magistrate. Negotiable Instrument Act 1881, the interim compensation under Section 143A shall be paid within how many days from the date of the order of within such further period not exceeding 30 days as may be directed by the court on sufficient cause being shown by the complaint. 60 days. Negotiable Instrument Act 1881, which defense may not be allowed in the proceeding under section 138 of the Negotiable Instrument Act 1881. He had no reason to believe when check was issued that the same may be dishonored. Negotiable Instrument Act 1881, in appeal against conviction, the appellate court may order the appellate to deposit fine or compensation awarded by the trial court. Minimum 20%. Which of the following presumption is prescribed under Section 118 Negotiable Instrument Act? Of consideration of date as to time of acceptance, इसके अलावा as to time of transfer, as to order of endorsement, and as to stamp, and that the holder is a holder in due course. All of these. Negotiable Instrument Act 1881, in which case Supreme Court held two private individuals are not included in the term other association of individual. The section 141 of the Negotiable Instrument Act is not applicable to the individuals. Alka Khandu versus Amar Shyam Prasad Mishra and others. इसके बाद में जीके के क्वेश्चन है which is not important for us. कंप्यूटर के क्वेश्चन है. So our paper is completed. So keep watching and keep sharing. Thank you so much. Have a nice day. नेक्स्ट वीडियो में मिलते हैं जिसमें हम हरियाणा जुडिशरी का जो पेपर है उसको डिस्कस करेंगे. So thank you so much.